Here's a question most people have never thought to ask. If you Google the owner of a major commercial building in your city, or the person behind a successful business, or the real estate investor who owns dozens of properties, you often find nothing. No name, no address, no public record of any kind. Not because they're doing anything wrong, because they formed their LLC in Wyoming or Nevada. Today, we're going to break down exactly how anonymous LLCs work, why Wyoming and Nevada are the go-to states for this strategy, how the ultra-wealthy use them to shield assets, protect privacy, and move through the business world without leaving a public trail, and whether this is a tool that makes sense for you. Let's start with the basics of what an LLC actually is. A limited liability company is a legal business structure that separates you as a person from your business activities. If your LLC gets sued, your personal assets, your house, your savings, your investment accounts, are generally protected. The lawsuit stays inside the LLC. Every state in America allows you to form an LLC, but not every state requires you to publicly disclose who owns it. That's where Wyoming and Nevada come in. Wyoming was the first state in the country to allow the LLC structure back in 1977. They invented it, and they built it from the beginning with privacy and asset protection at the core. Nevada followed a few years later with similarly aggressive protections and went even further on the liability shield side. The result is that both states have spent decades competing to offer the most favorable LLC environment in the country, and the wealthy noticed. Here is what makes a Wyoming or Nevada LLC fundamentally different from an LLC in most other states. First, no public member disclosure. In most states, when you form an LLC, you file articles of organization that list the members, the owners, by name. That document becomes a public record. Anyone can look it up. In Wyoming and Nevada, you are not required to list the members in the public filing. The only name that appears is your registered agent, a third-party company or individual whose address is on file with the state. The actual owner stays invisible to the public. Second, no state income tax. Both Wyoming and Nevada have no state income tax. So any income that flows through your LLC to you personally is not subject to any state-level income tax in the state where the LLC was formed. This eliminates one layer of taxation entirely. Third, extreme charging order protection. This is the big one that most people don't know about. Imagine a creditor wins a lawsuit against you personally. In most states, that creditor can attempt to seize your LLC membership interest, essentially forcing their way into your business to collect. Wyoming and Nevada have the strongest charging order protections in the country. Under their laws, all a creditor can do is get a charging order, which means they have the right to receive distributions if and when the LLC makes them. But they can't force the LLC to make distributions. They can't vote on LLC decisions. They can't take over your membership interest. The business keeps running. And here's the brutal irony for the creditor. Under a charging order, they may actually owe taxes on their claim to future income, even if no income is ever distributed to them. The legal and tax situation becomes so unfavorable that many attorneys advise their clients to settle rather than pursue a charging order in these states. Fourth, no annual report disclosing ownership changes. Many states require LLCs to file annual reports that update member information, keeping ownership records current and publicly visible. Wyoming and Nevada don't require you to disclose ownership in those annual filings. The public record stays clean of member names indefinitely. Fifth, low cost and simple maintenance. A Wyoming LLC costs roughly $50 to form. Nevada is slightly higher, but still low. Annual fees are minimal compared to Delaware, which charges significantly more and is better suited for corporations seeking venture capital, not privacy. Now let me explain how the anonymous structure actually works in practice, because this is where most people get confused. When a wealthy person or business entity forms a Wyoming LLC, they don't personally appear anywhere in the public record. Here's how. Step 1. Hire a registered agent in Wyoming. This is a person or company authorized to receive legal documents on behalf of the LLC. Their name and address go on the public filing. Yours doesn't. Step 2. Use a nominee manager if needed. Some people use a nominee, a trusted individual or another LLC entity, to serve as the manager of record. The actual owner remains a silent member. This adds another layer between the public record and the real owner. Step 3. Hold the Wyoming LLC inside a trust or another holding company. A common structure is to have a Nevada holding company own a Wyoming operating LLC, with a trust owning the Nevada company. At that point, you have 3 layers between the public record and the beneficial owner's identity. Step 4. Open business bank accounts under the LLC name. The bank will require you to identify yourself as the beneficial owner. That's federal law under the Bank Secrecy Act. But that information stays with the bank and the federal government. It is not publicly accessible. The result is a structure where the public, competitors, potential plaintiffs, and curious journalists cannot easily trace business assets back to you personally. Let me give you a concrete example of why this matters. Imagine you own 6 residential rental properties in a major city. You manage them under your personal name. A tenant slips and falls. Their attorney researches you, discovers you own 6 properties, sees that your net worth is significant, and structures a lawsuit designed to extract a large settlement. Not because your liability is clear, but because you're an attractive target. Now imagine instead that each property is owned by a separate Wyoming LLC. The tenant's attorney looks up the LLC. They find a registered agent in Cheyenne. No member names, no connection to you personally, no indication of your total real estate holdings. Suddenly, you are a much less attractive target, because even if they win, collecting is a very different conversation entirely. This is not hypothetical. Real estate investors, business owners, high net worth individuals, and even some public figures use exactly this structure. Now let me be direct about a question that always comes up. Is this legal? Yes, completely legal. There is nothing illegal about forming an LLC in a state where you don't live, hiring a registered agent, and maintaining privacy around your ownership. The IRS still knows who you are. You file taxes under your personal Social Security number or employer identification number. The Federal Beneficial Ownership Registry now requires most LLCs to report their true owners to the Financial Crimes Enforcement Network, what they call FinCEN. The information exists at the federal level. It is simply not publicly available. What is not legal is using an anonymous LLC to hide income from the IRS, evade taxes, commit fraud, or violate court orders. The structure provides privacy. It does not provide immunity from the law. Now let's address the common question about taxes. If you form a Wyoming LLC, but you live in California, do you avoid California income tax? No, you do not. The income you earn through the LLC flows to you personally. Where you personally live determines your state income tax obligation. California taxes its residents on all income, regardless of where it was earned or where the LLC was formed. So if you live in California, you owe California income tax on that income. Period. The tax benefit of Wyoming and Nevada is primarily for people who actually live in a no-income tax state, or for income that genuinely originates and remains within a business operation in those states. For everyone else, the primary benefits are privacy and asset protection, not tax avoidance. That said, there are legitimate scenarios where the state tax question gets more nuanced. particularly for businesses operating across multiple states, intellectual property holding companies, or investment entities. But those require specific tax counsel for your situation. Here's who this strategy makes the most sense for: real estate investors who want to separate properties into individual LLCs so one lawsuit doesn't expose the entire portfolio. Business owners who want to keep competitors from easily researching the structure of their business holdings. High-profile individuals. Entertainers. Athletes. Executives. Who don't want property ownership publicly tied to their name. Investors who hold significant assets and want to reduce their profile as a lawsuit target. Online business owners and content creators who generate income under a business name and prefer not to have their personal identity tied to that income source. And frankly, anyone who values financial privacy and understands that the less public information available about your assets, the harder it is for predatory actors to target you. Here's what the setup actually looks like, step by step. Choose Wyoming or Nevada. Wyoming is often preferred for privacy. Nevada for its additional officer and director protections. Hire a registered agent. There are dozens of reputable services that charge between $50 and $200 a year. File your articles of organization with the state, typically $50 to $100 in state fees. Create an operating agreement that defines how the LLC is managed and how ownership is structured. Obtain an EIN from the IRS under the LLC name. Open a business bank account in the LLC name. Transfer the assets or operate the business activity through the LLC. Total setup cost is typically a few $100s. Annual maintenance is minimal, and the privacy and protection benefits activate immediately. One final thing worth noting: the Federal Corporate Transparency Act, which took effect in 2025, now requires most LLCs to report their beneficial owners to FinCEN. This was specifically designed to reduce the ability to hide criminal activity behind anonymous LLCs. If you're forming an LLC for legitimate business purposes, this is not a problem. You file the report, the information stays at the federal level, and your public anonymity is preserved. If you're trying to hide criminal proceeds, the structure no longer provides meaningful cover. The bottom line is this: Wyoming and Nevada didn't become the dominant LLC states in America by accident. They made deliberate legal decisions that prioritize privacy, asset protection, and business-friendly administration. The wealthy have been using these structures for decades. The strategy is legal. The setup is affordable. And the protection, particularly for real estate investors, business owners, and anyone with meaningful assets, is real. If you have assets worth protecting, the question isn't whether an anonymous LLC structure makes sense. It's why you haven't set one up yet. Hit subscribe for more content on legal wealth strategies, tax planning, and asset protection that the wealthy use every day, and most people never learn about. Drop a comment below if you've ever used a Wyoming or Nevada LLC. I read every one.